Welcome back, ladies and gentlemen. In a previous episode, we drafted particulars of claim wherein contractual damages were claimed. As you now know, contractual damages arise from a breach of contract. In today's episode, we'll be drafting particulars of claim wherein we'll be claiming damages arising from a delict, in other words, delictual damages. Claims for delictual damages can be extremely broad, whereas in this episode, we'll only be looking at one example, namely a motor vehicle accident or collision. Most delictual claims will, however, follow a similar structure, so today's episode can be applied to numerous scenarios. We will also only be drafting the particulars of claim and not the summons component of the combined summons. We have drafted the summons components in several episodes already. Before we start, remember that the elements which must be present to successfully claim damages as a result of a delict are: the defendant must have committed an act or actionable omission that is wrongful, that caused harm in the form of damage or loss to the plaintiff because of the fault, whether intentionally or negligently, of the defendant. For more information on the theoretical aspects of delictual damages, check out our episode on damages. Also, if you haven't already, please also hit that subscribe button and follow us on our other socials. Let's get into it. Brief summary of facts giving rise to the plaintiff's claim. As already mentioned, our example today will be a delictual claim arising from a motor vehicle collision. For the purposes of our particulars of claim, the material facts are the following. We act on behalf of the plaintiff, Adam Driver. On 20 March 2022, and in Randburg, a motor vehicle collision occurred between our client's red Toyota Corolla and Nadine Smith's blue Hummer. Nadine failed to stop at a red light and as a result collided into the side of our client's vehicle. Neither party was injured. However, our client sustained damages to his vehicle in the amount of 150,000 Rand, being the costs to repair his vehicle to the pre-collision condition. Nadine's vehicle was also damaged. However, our client was in no way negligent. Nadine has refused to pay our client's damages despite demand. Our client approached our officers to institute legal action against Nadine for the damages caused to his vehicle. The heading and party citation. As always, we will insert the heading Particulars of Claim. We will then insert a subheading titled The Parties. As usual, we'll proceed to first cite the plaintiff and thereafter the defendant. In our example, we only know the defendant's residential address. Paragraph 1, being the plaintiff's citation, will state: the plaintiff is Adam Driver, identity number 94081750560089, an adult male actor residing at 12 Hollywood Avenue, Randburg, Johannesburg 2194. Paragraph 2, being the defendant's citation, will state: the defendant is Nadine Smith, identity number 93081905670087, an adult female dentist whose full and further particulars are to the plaintiff unknown, residing at 1 Honey Lane, Randburg, Johannesburg 2194. Jurisdiction. Before paragraph 3, insert the subheading Jurisdiction. If we revisit the episode on jurisdiction, how would we determine which court has jurisdiction in this matter? Well, we know that the defendant resides in Randburg, so we could proceed out of Randburg Magistrates Court. We are not going through High Court due to the monetary amount claimed. What else could we look at to determine jurisdiction? If you think about it, the vehicle collision, or the delict, also occurred in Randburg. This means that the whole cause of action arose within the jurisdiction of the Randburg Magistrates Court. Therefore, in this matter, the Randburg Magistrates Court will have jurisdiction as the defendant resides and the whole cause of action arose within the area. Take note that if the defendant resides in one area and the collision occurred in another area, the plaintiff may elect which jurisdiction to proceed in. Usually, whichever jurisdiction is more convenient for the plaintiff will be used. Our paragraph 3 will look as follows. The above honourable court has jurisdiction to hear this matter as the defendant resides and the whole cause of action arose within the court's area of jurisdiction. The motor vehicle collision. Next up, insert the subheading, the motor vehicle collision. Please bear in mind that you don't have to insert any subheadings if you don't want to. You can also title your subheadings differently to those in this example. I prefer to use subheadings as they separate the particulars of claim into organized categories. Nevertheless, under this subheading, we essentially need to explain what happened that resulted in our client approaching our offices to institute legal action against the defendant. Before we do so, let's have a look at Uniform Rule 18 subsection 10 and Magistrates Court Rule 6 subsection 9, which states inter alia that a plaintiff suing for damages shall set them out in such a manner as will enable the defendant reasonably to assess the quantum thereof. Tip: always consult Uniform Rule 18 and Magistrates Court Rule 6 before drafting particulars of claim, or any pleadings for that matter. Considering the rules of court and the requirements to prove a delict, we will need to set out the following in our particulars: the facts of the matter to enable the opposition to plead thereto, emphasis on the presence of the elements of a delict, and the quantum of damages and how they were calculated. In light of the above, we'll need to include the following information in our particulars of claim insofar as the collision is concerned: that our client is the owner of the vehicle he was driving. This gives us locus standi. The details of the vehicle, such as registration number and brand. The details of the defendant's vehicle, such as registration number and brand. The date on which the collision occurred. The place at which the collision occurred. That the defendant's vehicle was at all material times driven by the defendant. That the collision was caused solely due to the negligence of the defendant and the reasons for such an allegation. The defendant committed the act. It was the defendant's fault. It was wrongful. All of those elements are present. Confirmation that the plaintiff suffered damages, which refers to the act caused harm in the form of damage or loss to the plaintiff. The quantum of damages suffered by the plaintiff, how the plaintiff calculated the damages, and that the plaintiff demanded payment of the damages, but despite doing so, the defendant has failed and or refused to pay the amount. Okay, so at paragraph 4, let's start by describing the plaintiff's vehicle and mention that he is the owner thereof. This paragraph will state: at all material times, the plaintiff was the owner of a Toyota Corolla 2010 model bearing registration letters and numbers 123456 GP, the plaintiff's vehicle. Our paragraph 5 will state: on 20 March 2022, and at the corner of Dog Street and Cat Road, Randburg, Johannesburg, a collision occurred between the plaintiff's vehicle and the defendant's vehicle, a Hummer H3 bearing registration letters and numbers 678921 GP, the defendant's vehicle, which vehicle was at all material times driven by the defendant, the collision. Paragraph 6 will state: the collision was caused by the sole negligence of the defendant in that the defendant failed to stop at a red traffic light, failed to keep a proper and or adequate lookout, failed to exercise proper control over the vehicle driven by her, failed to take into consideration the rights of other road users, failed to apply the brakes of the vehicle driven by her at all, failed to comply with and adhere to the provisions of the Road Traffic Act, and failed to avoid a collision when by the exercise of reasonable care she could and should have done so. I have set out numerous reasons as to why the defendant was negligent. However, depending on the facts of each matter, the reasons for the negligence may vary. Okay, so we have now set out our client's basic version of events and illustrated that the elements of a delict are present. We now need to set out the damages suffered by our client as a result of the delict and how said amount was calculated. Paragraph 7 will therefore state: as a result of the collision, the plaintiff suffered damages in the amount of 150,000 Rand, being the fair and reasonable and necessary costs of repairing the plaintiff's vehicle to its pre-collision condition. A copy of the invoice from TW Autobody Pty Ltd, together with proof of payment, is annexed hereto marked A and B. Take note that damages to a litigant's vehicle is determined by the diminution in value of the vehicle. Generally, this can be done by proving the vehicle's pre-collision and post-collision values or the reasonable costs of repairs. In this instance, we are claiming the reasonable costs of repairs. Immediately after the paragraph setting out the extent of damages, I like to confirm the amount due and owing to the plaintiff by the defendant. So, in our next paragraph, we'll state that the defendant is therefore indebted to the plaintiff in the amount of 150,000 Rand, which amount the defendant has neglected and or refused to pay, notwithstanding demand. In the prior paragraph, we have mentioned that we previously demanded payment, so let's elaborate on that slightly. In our next paragraph, we will state, The plaintiff demanded payment from the defendant on 10 April 2022. Alternatively, the summons serves as written demand for payment. Take note that you should always demand payment first in a delictual matter. We've now set out the particulars of our client's claim, and all that is left are the prayers. In other words, the relief our client seeks. Prayers. You should know from our previous episode how to set out the plaintiff's prayers. In this matter, what is the primary relief our client seeks? Well, that is easy. It is the payment of 150,000 Rand for the damages sustained to his vehicle. Therefore, our first prayer will be payment of the sum of 150,000 Rand. Is the plaintiff entitled to claim interest on the amount referred to in prayer 1? And if so, at what rate and from which date? There is obviously no agreed interest rate in this matter, so we will have to claim the prescribed rate of interest. As a reminder, the prescribed rate of interest is the repo rate plus 3.5%. The repo rate often changes, so the prescribed rate of interest will also vary. At present, the repo rate is 5.5%, so if we add 3.5% thereto, we get 9. But before we can set out our interest prayer, we need to establish the date from when interest will begin to run. Is it the date of the accident? No. Interest begins to run from the date of demand, namely 10 April 2022. This is because we are dealing with delictual damages. Our prayer for interest will therefore look as follows. Interest at the rate of 9% per annum, calculated from 10 April 2022 to date of payment. As always, we will include a prayer for costs. The costs sought in this matter will be on a party and party scale, as there was obviously no agreement indicating otherwise. We won't strictly pray for party and party costs, but rather pay for cost of suit. This is the same as party and party costs. As always, our final prayer will be further and/or alternative relief. Signing off. As we are in the Magistrates Court, Rule 18 subsection 1 of the Uniform Rules is not applicable. What I mean is that a right of appearance in the Superior Courts is not necessary. You merely need to be an admitted attorney to sign the particulars. You will also include the usual details under your signature, such as your firm's address, its contact details, your file reference number, and correspondent attorney's details, if applicable. Conclusion. And there we have it. Our particulars of claim have been drafted. A template of the exact particulars we have drafted can be found in the downloadable episode notes. I look forward to seeing you next time. Cheers for now.